Beard for the respondent. Mr. Rosenfeld is now unmuted.
Good morning.
Good morning. David Rosenfeld for the Petitioner, Local 501 of the International Union of Operating Engineers. Local 501.
Mr. Rosenfeld, can you get a little closer to your mic?
Is this better?
Yeah, a little closer.
All right, this better?
That's much better. Go ahead.
All right.
Thank you. Yeah, thanks.
Local 501 organized 5 groups of slot techs in 5 casinos owned by the same employer. In each case, the employer refused to bargain, and in each case, either the Ninth Circuit affirmed the board's decision that this was an appropriate unit and that the slot techs were not guard. This court then entered consent orders in the other 3 in May of this year. This case involves one of those. Ms. Beard and I were on the same side in the case involving Palace seeking to enforce the board's judgment. We're now on opposite sides on this question. The first issue before the court that I want to address is this question having to deal with whether this court's decision in Terrace and other cases holding that where an employer does not raise the issue of confidentiality and offer to bargain about it, when the union makes a request for information that is relevant, does it then waive its right to bargain about that issue after certification is issued? And what I want to emphasize in terms of this oral argument is that we have a situation where the board has offered a number of rationales for changing its position with respect to this doctrine. None of these rationales meet any test of reasonableness decision making. Let's address the first issue that the board uses to justify this change in position. They say, well, we have to protect those few employers who happen to prevail in a test of certification from having to waive their right to do so. As we put out in a brief, there really is no right in the statute to do something illegal. The statute imposes limited remedies on the employer who refuses to bargain, but nonetheless makes it an unfair labor practice. And
now, just so that I'm clear, counsel, what are the remedies if an employer refuses to bargain on the basis that it believes that the union was not properly certified, but the board finds that to be, that defense to be, to the unfair labor practice to be without merit? What are the remedies available to the board at that point?
The remedy to the board is an order from a court ordering the employer to bargain with that unit. But attached to that obligation, that remedy, are many other aspects. For example, if the employer makes unilateral changes to working conditions during that period when it's challenging the certification, the employer can be ordered to reinstate the former conditions, make employees whole, and bargain over those matters retroactively during the year or 2 years it delays the certification. If the employer denies Weingarten rights to the employees be given those rights. So there are many of the remedies attached to it. And the statute also gives the union some leverage here because theoretically the union can engage in an unfair labor practice strike. And there's actually a strange position in the law that says if the employer is refusing to bargain after a certification, the secondary boycott laws don't apply. So the statute has built into it a mechanism to deal with the remedy issue, both in terms of the court order as well as in terms of what the union can do here.
Well, thank you. I mean, I guess then that raises a question for me is if all of those remedies are available, then why is it necessary that it also be available, so to speak, that the employer waives any right to challenge or on confidentiality grounds any information requests?
Because that, Your Honor, is what's built into the statute. Because the statute says the employer has a choice. You can recognize the union and bargain all mandatory subjects, or you can choose the other route. The other route has certain remedies and penalties applicable to it, but there's no in between. The statute doesn't envision part bargaining, part not bargaining, part replying to information requests, not replying to others, because
the board seems to believe that that the employers who want to both challenge certification and raise a confidentiality question can't really do both. You seem to think that's not accurate, right?
No, the board is correct that under what's been the law in every circuit that's had these issues before it, and the board up to this point, is that the employer is faced with between a rock and a hard place, but that's what the statute envisions. That is, if they have a confidentiality concern, or what's most unusual about this case is the board says, well, it doesn't apply to just confidentiality concerns. It applies, for example, if you need clarification of the union's request, if you think it's too burdensome, if you think it's not all relevant, you want to talk about the format.
Before you go, why is that catch-22 implicit in the statute?
It's implicit, if not explicit, in the statute, because the statute
Correct.
gives the employer one remedy, which is it allows the court to stay the board order. The board order is not stayed. And explicit in the statute is this choice. You either bargain with the union or you don't bargain with the union. If you don't bargain with the union, as Judge Randolph, you said in that decision issued on Friday in the Davidson case, you choose the option of committing an unfair labor practice. So the statute established by Congress, the procedure established by Congress was sort of a binary choice. You either bargain or you don't bargain. Nothing in between, because that makes no practical sense.
What if the employer says, you've asked for 10 things, we think that 9 of them are fine, but the 10th thing we think is confidential, and we'll give it to you so long as you sign a protective order or confidentiality agreement. We're not bargaining. This is, take it or leave it. This is what we'll do, but we'll give you all 10 things as long as you sign this agreement. And the union says, no, you have to bargain. What happens in that case? Or what would have happened before this decision in that case?
The union would have accepted the employer's offer, but that would have constituted under current board law and law of all the other circuits that dealt with this, an offer to bargain, and would have waived its right to test certification. It's sort of a bright line test here.
That's the dilemma the board is trying to avoid here, isn't it?
Yes, but that's a dilemma created by the scheme. For example, the employer is faced with a dilemma in all sorts of circumstances. It can't make unilateral changes, Your Honor, without bargaining with the union first. So the dilemma is...
But the procedure the board adopted here avoid that dilemma.
It avoids that dilemma on confidentiality, but it also, the way the board adopted it, avoids it on any issue regarding information request. For example, they say this applies to a union request that might be burdensome or irrelevant or not clear. For example, the second request having to do with customer complaints. If they were unclear as to how far we want or what do we really want, they could have certainly clarified that, and that's what bargaining is about, but they chose not to do it. So it is only a dilemma, but it's a dilemma that applies in every other circumstance where the employer is either testing certification or withdrawn recognition or refuses to bargain with the union. The statute and the process creates that dilemma. Either you recognize the obligation to bargain or you don't, and if you don't, there are consequences to it.
So help me understand what would have happened before this case if the employer had said, I'm not giving you anything because if I do, it'll be construed as bargaining, and I want to challenge the certification. And so the union has made several information requests. The union would request an unfair labor practice charge for refusing to provide the information and for refusing to bargain. When would the union be able to actually get any documents under the prior regime? It wouldn't be until after the certification issue had been resolved by the board, right?
Correct, but it would have gotten all those documents, information retroactive to when it made the request. as opposed to only potentially prospective after it goes through this lengthy accommodative bargaining process. So the point that we're trying to make in this case is that that interferes with the bargaining process. It means the union, you wait 2 years, then you sit down, and if to some of the information you don't get it, you may have to wait an additional period of time. You may not even get it depending on bargaining. Where under the old regime, you would have sat down the table and said, well, employer, you waived it, but I don't know of a union that would not have said to the employer, you got confidentiality concerns, we have a bargaining relationship, let's deal with it. And that's particularly appropriate here because you're dealing with slot techs, and these policies we are concerned about are the ones they know about. They're the ones that the policies that they have to enforce and live by. So this isn't one of these cases like in Detroit Edison, where you've got the confidentiality interests of the employees who took the test, nor is it a case like in Detroit Edison where you had a psychological test where nobody was seeing the test themselves. It was kept secret. And here the employer offered no evidence as to exactly how confidential these policies are. So
Let me try to understand the impact of the board's decision here. You're saying that now, instead of ordering the production of the documents, the board is just ordering the parties to bargain over the production of the documents. And what happens if the parties can't, if the union is dissatisfied with the bargaining over the scope of what the employer wants to produce? What happens then?
well, theoretically, you go back to another unfair labor practice proceeding or potentially a compliance proceeding where the board does what Detroit Edison and this court said in OCAW have to do. The board then has to balance the interests of the parties and decide whether the information the union sought really was that confidential or whether there's some other mechanism to provide it. That is a long-term delay. What we're seeking to avoid in this case, allowing employers to then delay the production of any information, bargaining on an accommodative basis while we're trying to get a first contract, which is always very difficult.
What in the statute, what provision of the NLRA has the board violated here?
It's violated 29 U.S.C. section 160 G, which says the board decision is final, subject only to a stay of the court. So the statute envisions in 29 U.S.C. section 160 F the right of either party to petition for review, and this kind of procedure violates that provision, other than the statute's been interpreted by this court and the Supreme Court to say you have a binary choice. You either bargain or you don't bargain. And if you do bargain on any subject, you waive the right to challenge the certification, and you've waived your right in a successorship case or withdrawal of recognition case or any other bargaining case to challenge.
But the dissent, as I read the dissent, the dissenting board member would have solved that problem by allowing, I think, bargaining over the information request without waiving the employer's objection to the certification. Do you believe that violates the statute also?
No, because that would allow the union to at least resolve this question, because that would have been a form of bargaining. You really can't avoid as a form of bargaining, but it doesn't waive the right. But such bargaining is not practical because there's no way to piecemeal bargaining.
But under the board's, just to continue the questions Judge Wilkins was asking you, under the board's new remedy, it will result in bargaining over, it'll result in one of two things, either bargaining over the information request or an unfair labor practice, won't it? Isn't that what you want?
No, because what we want is the information so that we can bargain a first contract rather than delay and interference with bargaining inherent and then trying to resolve additional questions. Remember, Your Honor, and
when you make your argument that way, it just sounds like, to me, the board has decided for whatever reasons that procedurally this makes more sense than the previous rule. But I haven't seen yet why that creates a statutory problem.
creates a statutory problem because this court has said repeatedly that you don't engage in piecemeal bargaining. You either bargain every subject or no subject, because bargaining is not effective if the employer says, we're not going to bargain about that issue, we're not going to bargain about this issue, we're not going to provide that information, because you can't bargain piecemeal.
Well, then why, to follow up on Judge Tatel's question, why then the dissent says that the better remedy than what the majority wanted to do was to allow the employer to bargain an accommodation of any confidentiality issues with the union? That's piecemeal bargaining, isn't it?
It is, and I didn't suggest in our brief that we agreed with that remedy either.
Well, I'm just trying to understand what your position is as to whether or not that is a remedy that is consistent with the statute. Is it or isn't it?
I really don't think it is, for the reason I've explained, that it's not effective. It's not going to do any good for either party, because you're focusing upon a very limited sphere of certain policies that may or may not be confidential, and you're not bargaining about the whole contract, so it doesn't do you any good, in my view, to do that. It's very impractical and violates, again, this principle that the courts have recognized, that inherent in the obligation to bargain in good faith is you bargain about all mandatory subjects. You can't pick and choose which subjects to bargain about, because that interferes with the bargaining process.
And just so that I'm clear, if the employer refuses to bargain over information requests or anything else, and the board ultimately considers that to have been an unfair labor practice, does the board is the board required to consider the employer's confidentiality concerns, or are you saying that those concerns aren't considered at all by the board because they have been waived?
If they've been waived, for example, if a union makes a request in a bargaining setting where there's no test of certification or withdrawal of recognition, and the union asks for it and the employer doesn't respond or refuses to provide it all, but doesn't offer to bargain about the confidentiality, it waives that right.
So let's suppose the union had requested, customer complaints, but it also requested the personnel files of all members of management, just for the sake of this hypothetical. You're saying that if the employer later loses its challenge to the certification, it has to turn over all of the documents that the union requested, including the personnel files of all members of management?
No, because there's a different issue triggered, Your Honor, by that question, which is relevance. Management personnel files are not presumptively relevant. The union would have to show some relevance. But in this case, remember, the board found the union's request for these policies relevant. So you get to the next question. Okay, it's relevant. You normally have to provide an employer. If you've got some confidentiality concerns, you either need to waive it or agree to bargain and resolve that question. So there's some things that are not relevant to bargaining, and the board would not issue complaint and we would not be entitled to it. And that's seen in this case where the board found, for example, that Social Security numbers weren't relevant and didn't order their production.
So relevance isn't waived, but confidentiality is waived?
That's right.
Why does that make sense? So let's suppose then you have, proprietary documents about, security, how slot machines work, et cetera.
Trade secrets, yeah.
Trade secrets, those get turned over without any sort of requirement that they be kept confidential by the union. The union could sell them to the highest bidder or do whatever it wants with them, post them on the internet.
Yeah, I understand that theoretically there could be some abuse here, but the board hasn't referred in its decision to any abuse by a union ever in getting this kind of information. And remember, that would be contrary to the union's interest to do that, because it represents slot techs in 5 casinos, and to do anything to undermine their job, their relationship with employers, would be contrary to the union's position. And keep in mind, again, this is a circumstance where theoretically these slot techs already know these policies. So there's not.
But the
real-
slot techs are under some sort of confidentiality obligations that are a part of their employment relationship, correct?
We don't know that. The problem in this case, Your Honor, is among other things that under traditional board law, if you have a confidentiality concern and you want to raise it, you got to provide some evidence. All the employer did in this case was simply state in its response to the order to show cause, oh, these are confidential, no factual information, no evidence. And in our position that having failed to do that, that's a waiver. And in the other 3 casino cases dealing with this, including NP Palace 1, the board said that doesn't effectively raise confidentiality because it's just a generalized concern for confidentiality without providing any specifics as to why it's confidential. No evidence, nothing. We don't know whether these policies are posted to the public in the casino when you walk in and say, here are the rules of the road, don't forget we're watching you. And we don't know that the slot techs are under any formal or informal confidentiality provision. And we don't know whether these are just the rules of the Nevada Gaming Commission. We know nothing about them.
You can still bargain over the questions you just raised, can't you?
Yes. For example, we can bargain about providing these.
Right. Now that the question of the validity of the unit has been settled, the answer is for you to go back and bargain.
That's true. We can go back and bargain, but when we sit down the table and bargain, we say, by the way, there's still this information request we didn't get. Okay, let's bargain about all the confidentiality issues, what we're going to give you, what we're not going to give you. And we say, wait a minute, we want to bargain about everything. And now you've shunted us off a different path when we should have had this information to start rather than delay the bargaining process from the get-go in the first contract, where we've got a year before theoretically the employer can withdraw recognition. So this becomes an interference again with this basic concept that when you withdraw recognition, you don't bargain after a certification, you don't recognize a union successorship situation. It's either you bargain or you don't bargain. You provide relevant information or you don't provide relevant information, and you waive your right if you don't offer to bargain about unilateral changes, information. That's the way the entire system works. And the board has never carved out an exception until this time, this case, to that concept that the union has to bargain about, the employer has to bargain about all mandatory subjects and provide all relevant information. I see my time is quite up here.
Yeah. Unless either of my colleagues has any more questions, we'll hear from
Judge Tatel, I had a question about the customer complaints and why is that ripe and final for us at this point? Why do we have jurisdiction to decide this issue?
It's because there is a balancing test. I understand that. And the balance falls in our favor here strongly because as to these customer complaints, we don't get them. And the board.
No, I don't think that's the question. I don't think that's the question Judge Wilkins asked you. The board says this isn't final because it's been remanded to the board. It's been remanded to the regional office to decide whether or not the information requested is confidential or not. In other words, it's not final.
It's right, relying upon this court's decision in the OCW case that held that where an employer delayed providing the information, that was a harm to the union. And it's more of a harm to the union in this case, because not only is it delayed potentially for years, just as not as extreme in the OCW case, but still delayed, but also the board has narrowed the circumstances under which we can get customer complaints to only those circumstances where there's been some adverse impact on the employees. For example, we can't get that information now for training purposes or to find out why you didn't discipline people. So the board has narrowed the circumstances and delayed, both of which are a harm.
I'm sorry, I'm confused. I thought the only thing the board decided with respect to customer complaints was that they're no longer presumptively relevant.
No, I think they decided they're presumptively relevant when the customer complaint has an impact such as discipline or you don't get a wage increase. They said otherwise it's not.
not presumptively relevant, then they're relevant.
They're relevant.
Yeah.
But I think once you say relevant, for this purpose, it means presumptively relevant. And as long as we can show what they said was, as long as there's some evidence that the customer complaint had that kind of an impact, it becomes relevant, presumptively relevant. Our position.
All right. Judge Wilkins, do you have an answer to your question there?
I'm not sure that I do, but I have no further questions.
Okay. Judge Randolph?
No, I don't.
Okay. Okay. Thank you. We'll hear from the board.
Good morning. I'm Heather Beard for the board, and we're here to seek summary enforcement of our order against the casino and denial of the union's petition for review. So as you've been discussing, what the board did here in this case is revise a remedy in information request cases such as this, where the employer has asserted a confidentiality or any other legitimate interest in requested information while it's pursuing judicial review of a union certification. And as the board thoroughly explained, the new accommodative bargaining remedy reconciles past conflicting precedent and does appropriately balance the competing equities between the employer and the union that are at stake. And here the board reasonably applied its new remedy, in which the casino timely asserted its legitimate confidentiality interest in information related to security and precautions against illegal gambling. So to begin with a discussion that Judge Wilkins was having with my esteemed opponent, Mr. Rosenfeld, here with regard to the dilemma. I believe that the union concedes that in these situations, there is conflicting precedent, or this dilemma, or as the board called it, a catch-22 between, on the one hand, if an employer has to offer to accommodate an interest such as confidentiality, this court and other courts, because the board has held, that means no longer can the board challenge or test certification because it must offer to accommodate such an interest. And in doing so, it then takes a step into bargaining, which waives its ability to test, which its right to test certification. And in this case, all the board did is say, you know, we're still going to put the employer on the hook for a violation. There is still a violation of the act, even if the employer does not offer to accommodate in something that they claim they have a confidentiality interest in.
Let me interrupt you for 1 second.
Sure.
Just to be clear on what the board's position is. So is it your position that if the employer says you've asked for 10 things and I'm willing to give you all of those 10 things so long as you sign this confidentiality agreement, union, but if you're not willing to sign that, then I'm not going to give you those things. That is an accommodation. That's a step into bargaining, and that waives their right to challenge certification later.
Yes.
Okay, continue.
So given that that is what the law is, what the board did within its discretion to assess remedies under 10C of the Act and to provide a remedy so long as it's not contrary to the Act, the board decided that in this narrow circumstance where there is a dilemma such as this, and there are particularly with confidentiality interests in the Detroit Edison case, when the Supreme Court has said that the board should not craft a remedy without due concern to confidentiality interests, the board, particularly cognizant of that, decided that it will still find a violation, but what it will do is allow the employer, if and only if it presents a legitimate, and there's the check on just any sort of claim, a legitimate confidentiality interest. For example, here, where it's clear on its face that should a casino have to turn over security, trade secrets, money laundering prevention, those types of things.
But let me interrupt you again. So prior to this case, if a union refused to bargain at all and refused to provide any information because doing so might waive their rights to challenge the certification, and the union brought an unfair labor practice was found, at that point, the board could order that documents would be turned over, right?
That's correct. The board would order that. That's true.
But under Detroit Edison, wouldn't the board have to give due regard for confidentiality anyway at that point? You know, I just don't understand where this waiver of confidentiality comes from.
Sure. Well, under Detroit, and in the Detroit Edison case, it was not, first of all, a case where there was the test of certification also ongoing. So the difference there is that there's a different there would be a test for confidentiality that would have to take place. However, if there was not only would there have to be a confidentiality interest shown by the employer, but even under Detroit Edison, under board law, the company would have also had to offer to accommodate the confidentiality interest at the time the request was made. And that's where the conflict in this case and those where there's a test of certification pending comes in, because in a test of certification, if you also have to offer to accommodate, then you're going to lose your ability to test the certification.
Then why not just get rid of that part of the board law and problem solved?
I'm sorry, Your Honor, I guess I'm not sure which part of the board law.
The fact that if you don't offer to accommodate at that point, there's a waiver.
Well, the board decided that the best way to reconcile, and as Mr. Rosenfeld said, there are courts, including this one, who have held that any step toward bargaining, such as accommodative bargaining like that, loses that right. The board has said, well, we can't make the courts of appeals change their precedent on that, but what we can do is strike a narrower solution that actually solves the problem while maintaining both the union's ability to later bargain specifically over that information and allow the employer to challenge the certification.
Well, I think I may not have asked my question clearly. So my understanding is that before this case, what would happen if an employer refused to provide information, refused to bargain over providing information, and it was later found to have committed an unfair labor practice for doing so, and any challenge to the certification was rejected. Then at that point, the board would simply order the production of the information that had been requested.
Yes, that's correct.
There wouldn't be any bargaining over it. The board would just order it.
That's correct.
Wouldn't the board at that point have an obligation under Detroit Edison to consider the employer's confidentiality concerns, even if the employer hadn't sought an accommodation or bargained earlier?
There wouldn't be, Your Honor, I don't believe there would be that sort of obligation or any process if there was such an obligation because of the way that the law stood at the time prior to this case. And so the board, rather than overturn, I believe, that precedent, which, there is a good reason for a violation to be found when an employer starts to bargain down one path while at the same time challenging a certification. That particular piece, that violation overall is there so that an employer can't, for example, start bargaining and then pull the rug out from under the union by saying, well, actually, your certification is bad. So there's good reasons why that constitutes a violation, but what the beauty of what the board did here is that in changing the remedy for specific cases in which there is a mechanism, a legitimate, in a pleading where there has been a showing by an employer that there's a legitimate confidentiality interest, they will no longer be ordered to simply turn over the information without that mechanism to preserve an interest that they may have shown that is legitimate. And so that's what the board chose to do here.
I guess all I'm saying is that why is there anything inconsistent with the statute for the board to just say that from now on, if an employer refuses to provide information and that's found to be an unfair labor practice, we will order turning over the information, but we will no longer rule that the employer has waived any confidentiality objections or protections that it has. We will just simply take that into account when we order the production of the documents and order them subject to whatever confidentiality requirements are appropriate in that case.
Sure, I think the board could have done something like that, but the problem with something like that, unlike here, is there wouldn't then be a mechanism for the board to adjudicate that confidentiality interest in the way that this type of a narrow remedy correction does, because now there can actually be bargaining over the scope of that, and that could be worked out by the parties, which is something that the act contemplates and would prefer, rather than a separate unfair labor practice proceeding. And therefore, under what you have posited, Judge Wilkins, there may not have been any sort of interest then. The employer would not have to show during the course of anything leading up to the board issuing its order any confidentiality interest. And then it seems to me the parties would have to start over from even an earlier point, which would delay things further. So I think the board's choice here, which was well within its ambit to do, to continue to find a violation and yet to, in certain circumstances, change the remedy, actually does best fulfill the interests of the employer and the union in these circumstances. Does that answer your question?
Well, what about all of the various forms of prejudice that petitioner says that this places it in, particularly its inability to really, get started with the bargaining and really represent the union effectively because it can't get basic information that it needs to begin that process?
Sure. I mean, the board wasn't ignorant of that, nor the board actually discussed that at some length in its reasoned decision. I believe it was on page 6 of the board's decision in order, where they said that they recognize that there may be some delay even after the certification is upheld. But the delay, as they noted, can only happen where there's been an asserted confidentiality interest that it's deemed to be legitimate. And given that in this instance, there was such a legitimate interest that was identified, the board found that it's going to choose not to ride roughshod over the confidentiality interest, but to allow there to be accommodative bargaining. And I do think that it's possible, even if bargaining has begun and not over this information, for the parties to get started. I mean, that's what the board was trying to do. This was a summary judgment motion that the board was trying to push forward as much as it could so that the certification issue could be resolved, and therefore the holding up just part of the information was something that the board considered as not too prejudicial to the union, while at the same time allowing the employer
Is there anything in the record to indicate whether these slot technicians sign non-disclosure agreements with the employer?
I'm not sure. I don't believe there is. I'm not aware of them being any. But I do know that.
The reason I ask that is the union is not totally without resource in getting ready to bargain, because it has available all the employees to talk to find out what, assuming that there's something that can be said about the policies rather than violating a non-disclosure agreement. The union is totally free to talk to its members to get information.
That's correct. And in fact, if during the course of the accommodative bargaining, the parties can resolve it and the union can agree, well, we don't need X, Y, or Z, or the company can say, what if we give you A, B, and E? And they can resolve those kinds of things. Even had there been some sort of non-disclosure agreement, anything can be, hopefully, and that's the hope, can be worked out in bargaining. And to the extent that right here, this solution that the board has crafted preserves precedent in the circuit courts, as well as preserves the fact that there is a violation of the act, but also just the remedy makes it such that any legitimate interest that an employer would have to offer to accommodate is no longer something that has to be done such that the employer waives its right. So we think that.
How does it work if the employer and the union bargains over confidentiality and they can't reach an agreement,
Sure.
but the employer is acting in good faith and the union is acting in good faith, but they just can't reach an agreement.
Right.
Does the board have any authority to resolve it, or is it just the employer never turns anything over because it was acting in good faith and the bargaining didn't reach a conclusion?
Right. If there was a good faith impasse and there is no charge filed by the general counsel that this was somehow a violation of the duty to bargain, then yes, you are correct. Then if whatever the employer has agreed to or not at that time, should there not be an unfair labor practice complaint, that's correct, would not be turned over. But the hope is, given the bargaining process, as there always is, that there would be some give and take and that something would be resolved. Or if the employer was acting, I mean, the check on the employer deciding to not act in good faith is exactly as the board contemplated an unfair labor practice charge, where that could be litigated such that the information, the board and then the court could decide whether it was required to be turned over.
And but thank you. And what about the authority and the precedent saying that the board can weigh confidentiality interests itself in a compliance proceeding or in conjunction with, just in order to turn over documents? Isn't there precedent that says that?
Sure. And the board recognized that its decision. There's one case which it has otherwise never, the board has never followed. Its traditional practice has been what the precedent had been before, which is allowing it to be turned over. And the board just decided that the better way to go would be to handle it the way that it did in this case. And indeed, there was no, I would point out, as we did in our brief, the union never raised that particular claim or objection to the policy choice of the board in its motion for reconsideration. So our position is that would be jurisdictionally barred from this court's consideration. But nonetheless, yes, the board did consider that and decided it was better overall for labor law policy to implement the decision and remedy that it did here.
Ms. Beard, I want to ask you something about the board's decision that employee complaints are no longer presumptively relevant.
Sure.
You say that's not final.
Correct.
Right? Because it's gone back to the region. But the union says in its reply brief that if the region rules against it, it has no way to challenge that issue. There's no appeal.
That's correct.
Isn't that right?
Sure. In the very unlikely chance that in this instance, the region or the general counsel didn't issue a complaint if the company challenges the relevance of a more specific and demonstrated relevance interest. While it's true, if there is no complaint issued, that is unreviewable. The test in terms of ripeness, we talk about ripeness, is whether the harm to the petitioner outweighs the board's interest in having the benefit of crystallizing its decision, its reasoning
But ripeness, when a court finds something isn't ripe, implicit in that finding is that the issue can come up later.
Sure, it could come.
Their point is that it can't here. That if the region, when this goes back, concludes that these are not relevant, that they'll have no appeal. So this is their only shot at that issue. So why aren't they right that it's final?
Sure. The board's position is that simply because there is a very small risk that there would not be any complaint issued should there not be information provided here, then the fact that the union wouldn't get to challenge the decision doesn't outweigh the fact that this issue is not one for which the board has issued a final decision.
Do you have a case that supports that?
The case that we cite in our brief.
Pardon me?
I'm sorry, I said that the case that we cite in our brief, the sheet metal case that we talk about in terms of when, if there is an issue and it comes back, if it comes back up, then the board would be able to further crystallize its decision on what is presumptive versus what is not presumptive, but yet is relevant. And as we've said in our brief, should the court disagree with our right.
here as you agree, it might not be able to come back up.
That's correct. A very
So
small
then why?
chance.
Okay, but even if there's a small chance, doesn't that mean this is final?
Well,
And
the
then
board-
I asked you for a citation for the proposition that, well, yes, it's final because there's only a remote chance that the union won't be able to, that the union won't succeed before the region. That's what you're basically
Sure.
telling us. You're saying, don't worry about this. There's only a remote chance that the union won't succeed in the region, right?
That's correct. And I don't have a specific site for that specific proposition.
I
You're
don't
right,
know
Your
of one, I don't know of one either. That's what's troubling me here.
Honor. Okay, that to the extent that we are saying that the test, as we understand it, for ripeness and for finality would
Okay.
not, correct,
Okay. All right. Okay. Judge Wilkins or Judge Randolph, anything else?
No.
No.
Okay. Mr. Rosenbaum, you are out of time, but you can take 2 minutes if you need it.
Judge Wilkins, you asked a fair question about why the union can't go to its members. I think there's a pretty clear answer. The members may not know, they may have conflicting views, and the board has always held that if a union has an alternative source that doesn't excuse the employer from providing its version of what these rules are. And Judge Wilkins, I think you've asked sort of a fair question about, is there a way of resolving it? And Ms. Beard is correct that I didn't specifically say there's this compliance proceeding, but the sheet metal workers case that Judge Tatel referred to was a situation where the issue of back pay, money only, was going back to a compliance proceeding where the issue of burdens of proof could be raised and litigated. Theoretically, what the board could have done in this case, and I think is still available, is to say, all right, we're ordering the production of these documents, and we're going to leave to a compliance proceeding any issues about confidentiality or other issues that were raised by the employer in a compliance proceeding. And that's what Detroit Edison says in all the confidentiality cases. They say, and this court has already recognized this in the OCW case, that if the parties can't resolve it in negotiations, the union files an unfair labor practice charge, and then the interests are balanced. The employer's interest in confidentiality is balanced against the union's interest in need, and if the balance is in favor of the union, the board orders the employer to turn it over. And that process is the way the board does it. That could have been a solution to this problem here, to give the union a fair chance to resolve it. Now, I want to conclude by saying I recognize that there's some attractiveness to the board's position here because it avoids the rock and a hard place the employer put itself in, but the statute says that's its choice. It either bargains or doesn't bargain, can't go halfway, because that would infect all sorts of other regimes of the act dealing with bargaining. Thank you.
Okay, thank you. Ms. Beard, Mr. Rosenbaum, thank you both. The case is submitted.
Thank you.
David, your screen curtain's on, you're invisible. They put a picture of you up.
Why?
There's nothing on your screen. There,
Am I back on?
yeah, there's Robert.
Thank you.
Check it out.
Ann, can you hear me?
I can, Judge. I can hear
my
you and
picture
see
back?
you.
I'm back now.
Yes, you are.
Wonder what happened.
We can hear you and see you very well now, Judge.
Okay.
They put a picture of you up.
Oh, is it a me or a
No,
picture?
now you're.
Okay, all right.
You went on.
We now see your video, Judge. We can see you again.
Okay, thanks, Ann.
You're welcome, Judge. May I call the next case?
Yes, please do.
Thank you. Case number 19-5174, Brian Hammer, Appellant versus United States of America. Mr. Dick, appointed amicus curiae for Appellant. Mr. Hammond for the appellee. Mr. Dick is now unmuted.
Good morning, and may it please the court. Anthony Dick for the court appointed amicus in support of appellant Brian Hammer. The clear text of the statute in question resolves this case, and because that text is so clear, there's really nothing for the court to do other than follow it unless it leads to an absurd result, a rational result. That's quite a high bar, and the government cannot come close to meeting it in this case. The statute provides simply that if at any time before final judgment, it appears that the district court lacks subject matter jurisdiction, the case shall be remanded. That's 28 U.S.C. 1447C. The shall in that sentence is mandatory. There's nothing in the text that suggests it has anything other than its ordinary mandatory meaning. And for that reason, the case shall be remanded. There's no question among the parties that—
Mr. Dick, if we agree with you and order and require the district court to remand this to the Superior Court, won't the Superior Court just dismiss the case?
It likely will. I believe it should, but that's
Well,
not—
why wouldn't that? Can you imagine the circumstances under which it wouldn't?
Well, if the complaint were amended, it's possible, I suppose. It might not, but in the case as it is now, I think the proper thing for that court to do would be to decide the sovereign immunity issue and then dismiss the case.
Mr. Hammer could have amended while the case was in the district court, couldn't he?
I think there are different rules that apply in state and federal court for amendments to be allowed or not. So it's
well, in federal court, that there was no responsive pleading, so he didn't need leave of the court or the concurrence of the United States to amend, but he didn't do it.
That's correct, Your Honor. But I think the issue is not so much what would happen on remand. The question is whether the court is obligated to follow the plain text of the statute, which puts the who decides question in the court of the state court rather than the federal court. And I think
doesn't 1440 or 1447C conflict with 28 U.S.C. 1631?
1631, is that the transfer statute, Your Honor?
Right. You have 1447C saying you shall remand, and you have 1631 saying that you may transfer the case to a court that has jurisdiction.
Correct, Your Honor.
Their intention, aren't they?
I don't think they conflict because, as I say in the brief, I think the transfer statute 1631 applies only to cases that are filed in the court. So I don't think it applies here. Even if the court disagrees and thinks that there is a conflict, I think that the narrow carve out of the may in 1631 authorizes a transfer, and there's a specific carve out from then the remand. So to the extent there's a conflict, it would allow the case to be transferred at most, but that's very different from allowing it to be dismissed. And I think there's, again, a rational purpose for that because Congress wanted to create a system where the case would be channeled to the proper forum and would not be dismissed. Congress.
Oh, wait a minute. This doesn't channel the case to a proper forum. It channels the case to a court that has no jurisdiction.
Well, it's a proper forum in the sense that it is the forum that Congress designated as resolving any jurisdictional defense in the case. So Congress could rationally decide what the text says. That is, if there's a case filed in a state court and there's a jurisdictional defense to be raised, a federal jurisdictional defense to be raised, that should be finally and conclusively resolved in the state court. That's the best way to respect federalism because we assume that state courts can resolve federal issues that are raised as a defense in the ordinary course. And if the plain text of the statute is followed, it's also going to deter the government from removing this type of case and pointlessly burdening the federal courts. Because if the court does what the statute says the government will know that it should just assert the very simple sovereign immunity defense in the state court, get that resolved there rather than coming into the federal
So
court.
the case gets, under your theory, the case gets remanded to the Superior Court of the District of Columbia, correct?
Correct.
And why can't the government then remove it again?
Well, because presumably it wouldn't want to engage in that kind of Sisyphean exercise where it would only have to be removed. Again.
There's nothing that would stop the government from doing that.
I think that's correct, although there is, I believe, a provision in 1447C that allows the court to impose attorney's fees. So it says, in order remanding the case, may require payment of just costs and any actual expenses, including attorney's fees. So I think if the government engaged in that kind of abusive behavior, it would start having to pay the costs.
Mr. Hammer doesn't have an attorney, does he?
I don't believe he does right now, but there are other costs associated with the case.
Why wouldn't law of the case and/or collateral estoppel apply?
Well, because there would be no final judgment that would be binding on the lower court. So it'd be a dismissal without
Well,
prejudice.
but there would be, the district court will have ruled it didn't have jurisdiction.
That's
Right.
right. That's right. So as
So-
I understand, and the government hasn't argued this, I think the reason for that is, as I understand it, for purposes of collateral estoppel, a dismissal for lack of jurisdiction does not have binding effect in another proceeding. So I think the state court.
So your theory is that by enforcing this statute, by having this court say shall mean shall, he's got to dismiss it, that in the future, the government won't seek to remove cases like this anymore. It'll just move to dismiss on sovereign immunity grounds in the Superior Court. That's
Correct.
your theory.
Correct. Right. And again, I think it's a very low threshold because the question before the court is not what the court thinks makes the most sense, not what even it thinks Congress was trying to do. We have a statute, we have clear text. And so the only question is whether the absurdity doctrine kicks in. That's an extremely high bar. It does not authorize courts to rewrite the statutes that Congress passed. It's just, is this irrational? And I don't think you can say it's irrational.
Well, there's another doctrine that is not embodied in any statute that the Supreme Court has recognized since its decision in Bell v. Hood in 1947, and that is that if a complaint is totally frivolous, then you can dismiss it without even deciding jurisdiction. And that Mount Healthy, I think, is another Supreme Court case. Bell v. Hood is the leading case. Why doesn't that apply here? The Superior Court clearly has no jurisdiction, and the Court of Claims has already decided that this is not a contract action. So no matter which case or which court the case gets remanded or transferred to, Mr. Hammer's going to lose.
Well, I think that's probably right, Your Honor, but I think that the statute really is quite clear. And to the extent there's any conflict with that doctrine, again, that's not a doctrine that the government has argued in this case, so I can't claim.
No, it's jurisdictional, though. I mean, it's at least a quasi-jurisdictional question.
Right, I agree. As I recall from my time clerking looking at an issue like this, if there's a totally frivolous claim, that would be another basis to say that subject matter jurisdiction is lacking. And again, I think that answers the question of whether there's jurisdiction, and then the question of what to do about that is answered.
It would still have to be, it would still, under your theory, even if the district court had invoked that theory, that jurisdictional theory, it would still have had to remand it, right?
Correct. Yes, that's correct. The statute says once you decide there's no jurisdiction, you shall remand.
Right.
But just so that I'm clear on how you think that all of this works, if we wrote a 100-page opinion explaining why the government is protected by sovereign immunity here, let's just for the sake of argument, and then we ordered the case remanded, your view is that the Superior Court could decide anew whether the government is protected by sovereign immunity and would not be bound by our decision in any chance and could reach a different conclusion.
Yes, that's correct. Because of the statute Congress enacted and the clear text of that, which does not lead to an irrational result, it's not irrational to say, we want the state court to have the authority to resolve the scope of its own jurisdiction in a case filed in that court.
And if the state court, let's say we find the United States is protected by sovereign immunity, it gets remanded, the Superior Court disagrees, and the government gets a judgment against it, and it appeals, where does that appeal go to? The District of Columbia Court of Appeals or to this court?
Goes to the DC Court of Appeals, and then of course there's a direct appeal, or I should say a certiorari available to the US Supreme Court from there. So there is a federal backstop, but I think it's, in this type of case, quite unlikely you're ever going to need that, because I think the presumption is that state courts are quite capable of handling this type of issue. It's not a terribly complicated issue, in this case at least.
Okay. I'm sorry, do you have something else, Judge Wilkins?
Well, so just so that I'm clear, you believe that what the Congress intended, or at least what the text of the statute requires, is that if we decide an issue of subject matter jurisdiction that involves like sovereign immunity, that essentially is for naught, because it gets sent back to the Superior Court to decide it again, and they could decide it differently, and the DC Court of Appeals could decide it differently. So Congress intended for the decision of the DC Court of Appeals to be the operative decision in that instance rather than ours.
Yes, Your Honor. I think, it's really more of what the statute says than it necessarily is what Congress intended, because as many of the cases that I cite say, there is a statute that is the law. And even if Congress may not have intended that, what has the force of law is the text that both houses voted on and the president signed. So it may be possible that Congress didn't intend this result, but this is what the words that Congress enacted require. I don't think they're absurd, and I think that ends the case.
All right.
Okay. Thank you, Mr. Dick. We'll hear from the government.
Good morning, Your Honors. May it please the court. My name is Derek Hammond, and I'm here today on behalf of the Appellant of the United States. The issue here is quite narrow. It is whether the district court correctly concluded that dismissal rather than a remand back to the state court was appropriate when the government successfully asserted its federal sovereign immunity. The answer to that question is yes. In every case brought against the United States, the plaintiff must be able to identify a statutory waiver of the government's sovereign immunity. And in this case, Mr. Hammer's sole claim was a purported contract claim against the United States for $37,000. Under the Tucker Act, the only court in the country authorized to adjudicate such a claims is the U.S. Court of Federal Claims. Thus, there is no dispute that neither the district court nor the state court from which this action originated had jurisdiction to entertain this case. Nevertheless, we're arguing over whether 1447C requires some sort of a different result to remanding the case back to the DC Superior Court, which plainly had no jurisdiction to hear it. That construction fails to account for the statutory context and yields a patently absurd result. I mean, it isn't.
Why is it absurd? Well, won't the Superior Court just dismiss the case?
Well, if we are to take...
Why is that so absurd? Why is that so absurd?
Well, if it invites the district court, or I'm sorry, the state court perhaps not to dismiss. And then we have these conflicting...
I mean, I know the argument that Mr. Dick made, but can you imagine any circumstances under which the Superior Court would not dismiss the case? I mean, you don't even think, you have, you don't even seem to think the Superior Court's going to go rogue here. You have, you say in footnote 8 that one can hardly imagine a case in which a district court, and on and on, right?
Yes,
so
Your Honor.
This isn't going to happen. And so why is it futile? Why? I mean, for us to invoke the absurdity doctrine, it has to be, the result has to be, and this is the language we've used, demonstrably at odds with the intention of Congress, of its drafters. I mean, sure, maybe they didn't think about this one aspect of it, but Is that really demonstrably at odds with the intention of the drafters?
I think sending a case back to a state court that Congress explicitly said should be somewhere else is demonstrably at odds with what they intended. They intended this kind of case to be brought in the U.S. Court of Federal Claims, not in the state court. It's also at odds with 1442A, because we know, based on Willingham v. Morgan, that Congress has decided that federal officers, and indeed the federal government itself, require the protection of a federal forum. And so, and that they amended 1442A specifically so that questions involving federal immunity would be resolved once and for all in a federal forum. So
But I'm not sure that statute doesn't, I'm not sure that helps you. Does it, that 1442A1 says, uses the word may, right?
that, yes, it gives the government an option to remove to federal
Well,
court.
my only point of mentioning that is Congress clearly knows the difference between may and shall.
Perhaps, but it also knew how to require a showing of subject matter jurisdiction before granting the power to remove, because that's what it did under 1441. It said that you have to have some sort of subject matter jurisdiction before you can remove, and that's not present in 1442A. So they clearly thought about and decided against requiring that sort of showing before the removal can be effected. And so both of these, both the Tucker Act and 1442A, demonstrate that sending this back down to a state court that no one argues has subject matter jurisdiction is a waste of judicial resources and party resources. And it's particularly important here when we're talking about an issue of immunity, because as the Supreme Court recognized in Seegert v. Gilley, one of the purposes of immunities is to spare a defendant not only unwarranted liability, but unwarranted demands customarily imposed upon those defending a long drawn out lawsuit. And this only has the effect of sending it to the federal court, sending it back down to the state court, and perhaps letting it continue on. And I would also like to point out that while sovereign immunity may be a fairly straightforward issue in our case, it's not always the case that sovereign immunity is so straightforward. And if a state court were to say, perhaps sovereign immunity is not, there is a waiver in this case, and it's allowed to continue, well, now the case is stuck in state court. There is no mechanism for the government to get back to the federal court, because under 1446B, a removal can only happen within the first 30 days of service of the pleading. So there could not be a further removal to federal court. Once the case is remanded back to state court, the government is stuck there. And the only way it can get a review of a decision that it hasn't waived its sovereign immunity, or excuse me, yeah, that it has waived its sovereign immunity, is to find its way up into the Supreme Court. That's clearly not what Congress intended here. Congress thought about and specifically amended 1442A to ensure that the case, that these sorts of defenses are raised and adjudicated in a federal forum, and that the next stop, if the district court concludes that there is no sovereign immunity has not been waived, the next stop is to a U.S. Court of Appeals. These are courts that are expert in dealing with federal issues like this, such as sovereign immunity.
Just a question about the Tucker Act. The Tucker Act never says in 1491A1 that the jurisdiction of the Court of Federal Claims is exclusive. It doesn't use the words exclusive, does it?
That is correct, Your Honor. It is a construction, it is construed to be exclusive, and this court construed it that way in Greenhill v. Spellings, because there is no other statute that waives the government's sovereign immunity for a contract claim in excess of $10,000.
I raise that because some of the cases that have employed this futility doctrine to say that, well, yeah, the statute says shall remand, but we should read, all of the statutes in context, and we can dismiss if reading everything in context, dismissal is the appropriate remedy. They have relied on the fact that, well, there's another statute that says that the only case you can, I'm sorry, the only court that you can bring this in is, this court, or that explicitly requires dismissal. And here you don't have that explicit language. Why isn't that a problem?
Because the rule of sovereign immunity is that it's effectively no court can hear it unless there is a statutory waiver. So that is akin to the statute that you're referring to in your hypothetical or in one of the cases you've read, because it says no other court. And Congress is operating under that framework. So when it says this court has jurisdiction to hear this case, but it doesn't delineate any other court, federal or state, that means that you can only go this route. And that's how the courts have consistently interpreted this framework under the Tucker Act.
That's despite 1331, which says the district court shall have jurisdiction, uses the word shall, right?
That's correct, Your Honor.
Right. And to get back to a point I made to Mr. Dick, is that despite 1331 and saying that the district court shall have jurisdiction, the Supreme Court has upheld the doctrine that doesn't apply when the complaint is totally frivolous.
Correct.
The shall doesn't apply. So why isn't the same thing true here?
Exactly, Your Honor.
So help me understand, what, if any, collateral estoppel effect the Court of Federal Claims' prior decision has, because the district court relied on that below, right?
Yes, Your Honor.
How and why does collateral estoppel apply to that ruling? Or are you relying upon that aspect of the district court's ruling?
Well, to the extent that everyone agrees that there's no subject matter jurisdiction here, the only import that would have at this point would go to the question of why you shouldn't transfer the case. And under 1631, you only transfer if it would be in the interest of justice. And where that court has already passed upon this exact question, it really isn't in the interest of justice to transfer it. And I think that, so the collateral estoppel issue comes into play there. And this court said in Daniels v. Department of Interior that a transfer that would be wasteful is just not in the interest of justice under 1631.
So you don't think that collateral estoppel has any role in our decision whether to dismiss versus remand?
No, I don't believe it required, when we're dealing strictly with the issue of sovereign immunity and the remand. I don't believe the court needs to consider it apart from the 1631 inquiry. I see that my time is up.
Let's see. Do Judge Wilkins or Judge Randolph any other questions?
No.
Okay. Thank you. Mr. Dick, you were out of time, but you can have 1 minute.
Thank you, Your Honor. I just want to make sure to direct the court's attention to the previous statute that existed before the current version of 1447C. And you can look at that on page 19 of the reply brief, footnote 3. And I think that gives a good example of how Congress could have written the statute if it wanted to provide the option to dismiss or remand. So what that statute said before the 1948 amendment is that the courts had the option to, quote, dismiss the suit or remand it to the court from which it was removed, as justice may require. So in 1948, the statute was amended to say the case shall be remanded.
Was
so
that in the general revision of the U.S. Code, of the judicial code?
Yes, Your Honor, I believe that.
And was there a notation that said that the changes were stylistic only?
I'm not aware of that, but I don't.
If it says that, if in the revision of the code it says that, that means that the new version of 1447C is to be construed in the same manner as the old version, correct? That's what stylistic means.
I suppose if it were to say it's stylistic and that were binding, that's correct. Although
it doesn't have to say binding. There's Supreme Court cases saying if it just says stylistic only, then you construe them as the same. That's an
If-
interesting point. I'd take a look at that.
Yeah, if the, what I meant was if the annotation were binding, then yes, but I wouldn't think that would override, again, the text, the clear text that's in the actual statute that says shall remand. I think that is the clear text of what it means. There's no linguistic ambiguity in the text, and it's not absurd to reach that result. And for that reason, I think the decision below should be reversed, and the case should be remanded back to the DC.
Okay. Thank you. Mr. Dick, you were appointed by the court to serve as amicus. You've done a fine job, and we are grateful to you for your assistance. Case is submitted.
Thank you.
Case number 19-7161, Mark Dimondstein, an individual, appellant, versus Jerry Stidman, an individual, and Jonathan Kelley, an individual. Mr. Langberg for the appellant, Mr. Bob for the appellees. Mr. Langberg is now unmuted.
Morning.
Good morning, Your Honor, and may it please the court. I'm Mitchell Langberg for Mark Dimondstein, the appellant in this case. It occurred to me as I was watching these proceedings, Your Honor, that there's people presumably from all over the country listening to these proceedings on YouTube. And I wonder if we put judicial proceedings privilege aside and other privileges, if I were so bold and foolish to defame one of Your Honors in the course of this proceeding, would Your Honors have to come to the district court for the District of Las Vegas to sue me for defamation? Or would you in your home state, where your reputation has been harmed, where you suffer mental anguish, where your job perhaps has been put in jeopardy, be able to sue in your home state? That's the question that's before the court today, a question that this court has not directly answered. Mr. Dimondstein resides in the District of Columbia. He works in the District of Columbia. When he suffers professional harm to his reputation, District of Columbia is where it's most felt, including financial harm, potentially risk to his current job, and potentially his future income or future employment opportunities. When he suffers mental anguish, the District of Columbia is where it is felt. Yet the appellees, the defendants below, for the purpose of destroying Mr. Dimondstein's reputation and causing him to lose his job in an election for president of the American Postal Workers Union.
I thought he won the election.
He did, Your Honor. He won the election.
Causing him to lose his job?
For the purpose of causing him. Their goal was to damage his reputation.
Okay.
They published these false and defamatory allegations that accused him of crimes or being involved in money laundering. So where is...
I just have a couple quick technical questions, okay? So the Indiana defendant, he put this on his own website, right? Is that where he put it?
That's correct, Your Honor.
And that's accessible. Anybody could Google that. Is that correct?
That's correct, Your Honor.
Okay. And then the Wisconsin defendant, that was on his Facebook page?
That's correct. He posted a link to that first article. Yes, Your Honor.
And is that, how accessible is that? If it's, you have to remember, I don't use Facebook.
Your Honor,
not even my grandchildren. But what, at the time this was posted, as I understand it, a Facebook page can be limited to just your friends or can be available to anybody, right? Do we know from the record what one was?
Your Honor, I'm sorry for interrupting. You broke up for a second, but he actually posted it to, so on Facebook, a person can create a group or organization And that defendant had created that, and then he can allow anybody who asks to be a member of that group to be a member of that group. And this
Right.
group was targeted towards other members of the American Postal Workers Union. So I don't recall offhand how many members of that group. I think it was upwards of 3,000 there are, but that's approximately how many people that Facebook post was available to.
Okay, so your theory then is that when something is uploaded or quote uploaded or quote published on the internet, it's published everywhere, right?
That is correct, Your Honor. It is published everywhere.
Uh-huh.
But that does not mean, Your Honor, that there is either jurisdiction or venue everywhere. Of course, there can't be. And the case out of the District of Maryland that we cited
Clearly,
with an
there can't be
extension.
venue. There can't be venue in Wyoming in this case, right? But under your theory, there would be venue would be proper wherever in a defamation case, wherever the person, the target of the allegedly defamatory statement lived, correct?
That's correct,
Or
Your
worked.
Honor. Yes, Your Honor. Because in most circumstances, and I'm not sure that I can think of a particular circumstance offhand. I don't want to make that absolute, but I think that one could adopt the discussion in the Tatel case out of the District of Maryland that at least allows for that to be in most cases. And also, by the way, this court's decision in Crane, which was about personal jurisdiction, but also talked about where the injury is most substantially felt. And of course, again, Your Honor, we're talking about a statute that allows venue wherever a substantial part of the events giving rise to the claim occurred. And substantial, as the cases have informed us, does not mean the largest part or the most part, but a substantial part. And following just about any court's jurisprudence in defamation law, which admittedly in this day and age presents some unique circumstances, we all know, as this court said in Crane, the act of defamation is not where it originates, but it's where it arrives. It's where it's read. It's where the readers have some reputational impact on them about the target. And so that could be just about any state. So the cases,
the defendant says, they say in their brief in response to Crane, well, that case involves personal jurisdiction, not venue.
That's true.
And venue, what's your answer to that?
Well,
I mean,
I wish
Crane is a personal jurisdiction case.
It is a personal jurisdiction case, and we cited in our reply brief in a footnote, and I will try to pull it up, Your Honor, that the courts have recognized that the issues of venue and personal jurisdiction are closely related. And that doesn't mean they're identical, but certainly in this context, because the issue of venue looks at where a substantial part of the claim arises. In a defamation case, particularly an online defamation case where we have this issue that it goes everywhere, we need to look at other indicia. And what the courts have done for both personal jurisdiction and venue is look to where the harm is most substantially felt. And so the court can look at the Crane case because there's a great discussion about where defamation occurs and where harm is felt. And then we can move to the district court cases that have almost uniformly, but not uniformly, taken the approach that we offer in our brief. And again, I keep mentioning the Tatel case, but we also cite Wright and Miller that cites a host of district court cases from all over the country that talk about this issue, which seems logical, especially in the context of the illogical result that would otherwise happen. It's logical for the reasons I said. Whether I was foolish enough to defame one of you or the defendants, in this case, who defamed Mr. Dimondstein, the effect is felt at home and at work, which are both the same place for Mr. Dimondstein. That is one of the places where the publication necessarily occurs. That is where he is injured. That is where he suffers his mental anguish. That is where the courts and the law whose job it is to protect Mr. Dimondstein, the state that has interest, or the district. And the absurd result in the other situation would be that we have these two defendants who may or may not have worked in collusion with each other, that a venue determination contrary to what we assert would result in Mr. Dimondstein either having venue in no court or having to raise the same claims based on the same facts and circumstances and the same defamatory allegations in two different district courts, because there's no evidence that there's personal jurisdiction of either defendant in the other defendant's home state. So, Your Honor, if there's no more questions,
you.
I'd like to reserve the balance of my
Let
time.
either of my colleagues have any questions? We'll hear from Mr. Bob.
No.
Thank
No.
you. Okay.
Thank you very much, Your Honor. Jim Bopp for the defendants. I think the essential problem of the plaintiff's argument is they misunderstand what the facts are about. This was not about, this was about campaign speech in the context of an election. The election was for president of the union. And the people who vote on that in that election are the members. The members are all over the United States. So the targets, if you will, or relevant recipients of the information are members who are all over the United States. Few of them are in DC. DC does not even have the largest chapter. And that's what the district court found, that the alleged defamation, if anything, would damage the reputation of the president of the union with union members in the context of an election.
Well, Mr. Bob, can I just take you back to, can we start with the statute here for a minute? The statute says that venue is proper in a judicial district where a substantial part of the events giving rise to the claim occur, okay? Now, the claim here is defamation, right? It's a defamation case. And under DC law, to prove defamation, you have to show at least publication and injury. You have to show at least those two things, injury and publication. And this is a motion to dismiss, so we look at the complaint, and the complaint alleges that he works in the district, that he suffered injury and mental reputation in the district. And so why for purposes of a motion to dismiss, isn't that adequate? Why isn't that enough to say that the substantial portions of this claim arise in the district? This is where the injury was, and this is where the publication occurred.
The complaint does explain the
Remember,
context.
the motion to dismiss. The motion to dismiss. We don't know. I mean, even if there's only one member of the union in the district, we just don't know that at this point. I mean, you might be able to show, in summary judgment, that there aren't any union members in the district. I don't know, but he's made these allegations.
Yes, well, two things. One, you have to look at the context, which is in the complaint. And the context is this was campaign speech about his election. The election occurs by votes of members all throughout the United States.
Right, but his allegation is that the allegedly defamatory statement injured him with members in the district. This is where he was injured.
Well, he didn't talk about.
In fact, from his point of view, they don't even have to be in the district, right? If they affected their vote anywhere in the country, they injured him in the district.
No.
Isn't that right?
No, because his position he's running for an office in the union. The fact that the union headquarters happens to be in DC is of no pertinence. Secondly,
he's in the District of Columbia. This is where he was injured. If he was injured anywhere, he was injured here, wasn't he?
His injury.
Where else could he conceivably have been injured?
He alleges his injury to be with respect to the election for president of the union. That's what he alleges. He doesn't even allege that anyone in the district ever saw or read the blog posts at issue. So if the complaint fails just simply on causation, what is if no one read the post, how can he claim an injury in DC? And secondly, if this statute needs to be read to protect defendants. It's written to protect defendants. And his theory means that he could sue anywhere in the United States, or even perhaps in the world, because anyone in the United States or the world could see this post potentially.
But that contradicts what you just said.
Right.
I mean, you're saying that the injury that he is alleging is the injury to
his election.
Because someone may have seen the post and believed it, and that would have caused them not to have voted for him. So you're saying that the theory of his complaint is that the injury is essentially wherever union members are. But I guess what Judge Tatel is saying is that, isn't it also a fair reading of the complaint that he's saying that he is injured because his reputation is harmed and that injures him?
Yes, and the problem with this broad reading is that it reads out of the statute the word substantial. It can't be just one union member in Alaska read the post and therefore he can be sued in Alaska. I mean, these defendants can be sued in Alaska. They're reading out the word substantial. And of course, that's much different than, for instance, the Walden case, where the National Enquirer was allowed to sue in California, but there was a substantiality showing. This is where most of the subscriptions of the National Enquirer were. And if they suffered loss of subscriptions in California, it could substantially affect the publication. Well, none of those showings are here. I mean, the only pertinent, the most pertinent fact is this is campaign speech directed at union members who are voting in an election. And any loss is the loss of the election that he is talking about, that it would adversely affect his re-election as president.
Suppose instead of the defendants having put this on the internet, they had sent a letter to every member of the union.
It would be the same situation.
Then you wouldn't be proper here? Then you would not be proper?
Except in that case, that fact would demonstrate the likelihood that somebody actually in District of Columbia actually saw it and read it. I mean, he doesn't.
Why?
Because to read something on the internet, you have to access the website.
But he says this is a motion to dismiss. He says he was injured.
Well, but he doesn't prove causation that anybody read it in DC. I mean, it's from the complaint. There doesn't say anything about that. And when you're talking about posts on an internet, there are steps that people have to take in order to access it.
The issue that we're discussing has come up over many years, but not in the context of the internet, but in the context of newspapers. For example, the New York Times, which newspapers appear in probably every jurisdiction, every state of the union, and one of the problems that your interpretation of the venue statute seems to solve, but is that you could get a libel action from something printed in the New York Times and have a cause of action in every state of the union. I mean, that's one of the things that motivated the Supreme Court to decide New York Times versus Sullivan in the way that they did. And so, which leads me to this question: what if he had sued simply in the Superior Court, where the 1391 doesn't apply?
I think it's pretty clear that the Superior Court does not have personal jurisdiction. I mean, that's.
It would be decided on personal jurisdiction, not venue grounds.
Yes, and the court below didn't reach that, even though he expressed serious doubt about whether there was personal jurisdiction in the context.
And let me just follow up on that. I mean, I understand that Mr. Langberg argues that, well, the payment of dues, union dues, but my understanding is that the payment is, that the old checkoff system is gone, and it's a deduction from wages, and the deduction would have occurred where these two gentlemen were employed by the post office, right? And not only that, but the money is collected by the local union, not by the international. Isn't that correct?
Yes, and that's you know, again, this is such a broad interpretation that would mean if that was a sufficient minimal contact under the DC statute and under the Constitution, that would mean that everybody that joins any organization could be sued basically wherever the organization is, just by the mere membership or the mere payment of dues. So that, you know, well, we're not protecting defendants anymore with this. We're empowering, you know, situations in which there can be actually grotesque forum shopping, looking for, you know, the state that has either, you know, the best laws anywhere in the United States or perhaps the world, and that turns the statute on its head. So the protection.
I must be missing something. I don't understand the forum shopping concern here, where the plaintiff is selecting the jurisdiction where he lives and works.
Well, but he's claiming an injury. What is pertinent about where he lives and works is he's claiming an injury there. But of course, as he concedes, any member who read the blog post, they are claiming that the reputation of this guy running for re-election would be adversely affected. And therefore, one member reads the blog post, they don't even allege that, but let's assume, reads the blog post, can be sued anywhere because they'll say that's where the injury occurs. The pertinence of living and working is the common sense idea in some cases, where you know, that's where the decision makers are that decide whether or not you're going to be employed. Okay, so the supervisors and the, you know, plant supervisors, etc., decide whether you're going to be employed. Well, that's not the case here. It's members all over the United States that decide whether or not he's going to be.
Well, the other consideration that's troubled me a little bit is that the venue statute 1391 ad B2, I think it is, doesn't speak in terms of where the injury occurred. The injury could have occurred anywhere, but the statute talks about where the events leading to the injury occurred.
And of course, the events are the posting of the items on the internet. And I would think they would have to allege that somebody actually read them that was pertinent to the jurisdiction they're claiming. And so, and it's important to read this venue statute as Congress intended, that it was to protect the defendants, not to enable the plaintiffs to sue absolutely wherever they want to. I see my time is up. Thank you.
And did counsel have any time left?
Council had no time remaining. Oh, council had 1 minute and 15 seconds. I'm sorry.
Okay, go ahead, go ahead.
It's interesting that I'm arguing for a more conservative approach to venue than counsel is arguing. Nobody has argued that every place where it's published results in venue. What we've said is that a substantial part, so as the statute says, a substantial part of the events giving rise to the claim occurred. And as I've said, this court recognized, and Crane as other courts have recognized, it's the receipt of the publication, and it is also the harm to the reputation that give rise to the claim. And those occurred substantially, not exclusively, but substantially in.
Where did but the events, it has to be the events giving rise a substantial to a claim, right? It doesn't say where the injury occurred, does it?
No, but Your Honor, the damage to reputation is one of the events that give rise to the claim. The
And so
existence of,
so is the initial posting. Where did the initial posting occur?
well, those occurred in their home states, Your Honor. And as we know, while none of us would argue that venue could exist or should exist everywhere, we also know that the law is not that venue only exists in one jurisdiction. So here, there might be for each defendant 2 jurisdictions where venue is proper, both the District of Columbia and the defendant's home jurisdictions. Remember, they targeted this. Mr. Bopp seems to argue that this is to protect defendants, but defamation law is to protect the people who have been defamed. These defendants aimed their attack at Mr. Dimondstein in DC. They intended for him to lose his job in DC by damaging his reputation. They intended him to suffer mental anguish in DC by an attack on his reputation. And let's recall also that under DC law, harm is presumed when there is defamation per se, as we have alleged, which means that the harm is assumed to happen everywhere that his reputation.
Yeah, where is personal jurisdiction? How do you get to personal jurisdiction in the District of Columbia?
Well, Your Honor, I believe that under the Crane case, personal jurisdiction occurs in DC, exists in DC. Obviously, it exists in the defendant's home states, but I believe that the District of Columbia also has personal jurisdiction over these defendants under the Crane case because they caused injury in the District of Columbia. That's what they intended to do. And we don't even need to get to the District of Columbia plus factors under that standard. If we even get to the District of Columbia plus factors, I might note that we're not alleging that simply because they're members of an organization that pay dues, but in addition, they through this organization, they negotiate their employment contracts in the District of Columbia. So the organization acts as their agent to do things that they otherwise would be doing in the District of Columbia, which we believe
These individuals negotiate their employment contracts in the District of Columbia?
They're through the union that they belong to, who acts as their agent.
Union? The local union?
No, the national union handles things like negotiating health benefits with the United States Postal Service.
Okay.
And other collective bargaining issues. So there's some things that happen at the local union. They pay dues to both the local union and the national union, and they, through their membership in the union, have that union act as their agent in the District of Columbia to negotiate with the United States Postal Service, which, if there were no union, they would have to do on their own on an individual basis.
Okay.
We believe that's a significant plus.
Are you familiar with our GTE new media case?
I can't say that I am, Your Honor.
Okay. We held there that the mere fact that something can be downloaded from the internet in the District of Columbia is not sufficient to confer personal jurisdiction. I just wondered how you distinguish that case.
Well, I don't, so that's not too different from other cases. I think that is I'm not prepared to say a uniform rule because I haven't dealt with it in every district, but I think the rule is the same in the Ninth Circuit, which I'm much more familiar with, Your Honor. But pardon?
No, go ahead, you finish. I didn't mean to interrupt you.
Well, I apologize, Your Honor. I'm supposed to stop as soon as you start speaking.
No,
but
not when I interrupt you. Well, since we're not talking.
Yes, Your Honor.
You're not arguing. You're not arguing that you're not arguing that we have to decide personal jurisdiction here, are you? The district court didn't decide that, right?
That's correct, Your Honor. The district court did not decide the issue. I don't believe it's before the court at this time.
It's not before. So if we were to agree with you on venue, we would send it back to the district court, right? To decide personal jurisdiction, correct?
I agree with that, Your Honor.
Even
okay,
I just wanted to point out that there are precedents in our court that say that when you have a venue question and a personal jurisdiction question, that you should decide, you should decide the personal jurisdiction question first. Are you familiar with those cases?
Yes, Your Honor, and I think that counsel, frankly, for both sides, and I don't mean to put words in Mr. Bopp's mouth, but I think based on the briefings below, you would see that counsel for both sides believed that the court would decide the personal jurisdiction issue first.
Yeah, but didn't. And then there is at least one case in our circuit that says if the district court goes ahead and decides venue without addressing personal jurisdiction, the district court has to give reasons for doing it that way.
I'm not familiar with that authority, Your Honor, but it makes sense.
Yeah, okay.
What about Mr. Bopp's argument that there's no allegation that anybody in the District of Columbia read this?
Were it necessary, and I don't think it is, but were it necessary to make that allegation, then the court below should have given us leave to amend, because that certainly is not something that's not curable, particularly on a simple venue motion.
Well, do you think it's necessary?
I don't think.
What's your argument for it not being necessary?
I don't think it's necessary because I think, as Your Honor mentioned before, it actually doesn't matter whether anybody in the district read it. The fact is that even if every single person who read it was in every single jurisdiction that the union members were in, except the district, the harm to reputation affects Mr. Dimondstein in the district, both for his potential current and future employment, for emotional distress, as we've discussed, and for other things. And that's exactly one of the things also that the presumed damages rule is supposed to address. Presumed damages without, I see we're way over, but presumed damages says there are some defamations that are so bad, the per se defamations, that a person might not even know who it's been communicated to. Who has the first person told the second person to the third person. And so presumed damages allows a person to bring a defamation claim without any proof of actual harm to reputation whatsoever, allowing the jury to presume such damages and determine what harm that is. And the last point related to that, Your Honor, if I may, it'll take 12 seconds, is if the court were to look at the cases throughout the country on issues of statute of limitations for defamation that's published on the internet, a plaintiff can never say, I didn't see it. I'm sorry, I didn't see it. So the statute of limitations didn't run because of delayed discovery, because the law presumes that something that's out on the internet is seen by everybody that it's available to be seen by, at least for procedural issues.
Okay, thank you. Mr. Langberg, Mr. Bopp, thank you both. The case is submitted.
Thank you, Your Honors.
This honorable court is now adjourned until Wednesday, October 28th at 9:30 a.m.